Hello and Namaste. I am Ketan from 192 Consulting. We have been doing these videos regarding reclaiming of shares securities from the Investor Education and Protection Fund Authority for quite some time now. Over a period, we have received a lot of questions. There has been a question answer series that we have done in the past, but after that considerable time has passed and we have again received a set of questions which we are going to take up in this series. Out of all the questions that we have received, there are in all 30 questions that we are going to address in this series of question and answer sessions. I've got the questions listed out in front of me. We are going to take up 3 questions per video so that answers can be given in a proper and elaborate manner. So let us start with first question, which deals with the succession certificate. The investor here has asked us, can succession certificate be issued in single name if there are multiple legal heirs? So succession certificate primarily deals with the movable properties. We have earlier made a video which elaborates or which focuses on the difference between the succession certificate and the legal heirship certificate. The one basic fundamental difference between the succession certificate and legal heirship certificate is that legal heirship certificate includes or it takes into its ambit the movable as well as immovable properties, whereas succession certificate can be issued only for the movable properties. So inherently, as per the provisions of Indian Succession Act, succession certificate can be issued in the single name, but the other legal heirs have to testify and provide their no objection to the applicant as per the provisions of that act. In case the legal heirs object, then the matter will be contested in the court and the honorable court will issue the appropriate order as it deems fit. But if the other legal heirs are ready and if they have granted their no objection, they have testified accordingly in front of the honorable court, then the succession certificate may be issued in the single name where multiple shareholders or multiple legal heirs are there. Next, can succession certificate once issued be amended? So this is again related to the succession certificate. There are provisions in the Indian Succession Act to make amendment to the succession certificate. So the basic rule is that if a succession certificate is issued on a particular asset, on a particular property, then a succession certificate cannot be issued or cannot be issued on the same property. If there are any changes, then an amendment provision is there. If I am recollecting it correctly, section 376 of the Indian Succession Act deals with the amendment of succession certificate. So this precisely can be discussed or elaborated taking an example that if the succession certificate has been issued long ago by the honorable court and if there are due to certain corporate actions, if there are if the number of shares or the folio number gets changed and if that asset is not covered in the previously issued succession certificate, then an application can be made to the honorable court to amend the succession certificate. Appropriate prayers have to be incorporated in that amendment application. A hearing will be held, proper legal process will be undertaken, and then if the court is satisfied, the succession certificate will be amended, which will be allowed by the RTA, the company and the Investor Education and Protection Fund Authority. So to answer the question, succession certificate can be amended. There are provisions to that effect, but the procedure has to be followed. Third and last question in this video, in case there are multiple legal heirs, some legal heirs are based out of India, then the legal heirs which are based out of India, can they issue a power of attorney to do all the things which are required to reclaiming of the shares in favor of the legal heirs who are present in India? So that's the third question. I'll summarize the question. There are multiple legal heirs. Some legal heirs are based out of India, others are in India. The legal heirs who are based out of India are willing to issue or can they issue a power of attorney in favor of the legal heirs who are there in India and who are in the position of getting the procedure done for reclaiming of the shares. Now, the power of attorney can be issued by the legal heirs or by the persons who are out of India. The basic intention of that document named as power of attorney is that a person in whose favor the power of attorney is given is authorized to do all those things which are required to be done in the absence of the person who is giving the power of attorney. But two things very importantly that one should note over here is that one, the power of attorney has to be registered in front of the sub-registrar. A simple notarized document will not do. The power of attorney has to be registered, and secondly, the clauses of the power of attorney have to be drafted meticulously so that there is no ambiguity in their interpretation, and the person giving the power of attorney and the person in whose favor the power of attorney is given are enabled, both of them are enabled to conduct all such things or do all such acts which are necessary for or for which the power of attorney is intended and which are necessary for reclaiming of the shares. If you have any questions, any queries, any issues relating to the reclaiming of the shares, you may feel free to reach out to us. You can reach out to us by writing an email on info@192.in, or you can simply mark a comment in the comment section of this video. Till then, this is Ketan Kank signing off. Thank you so much.